Hello, and welcome to Thinking Boldly. This is the podcast series of the Concilium Institute, where we talk to amazing professionals who work in the divorce and family sphere. I am retired Judge Julie Field. I'm here with my partner, Heidi Webb, who is the co-founder with me of the Concilium Institute. We are very honored today to have as our guest Magistrate Kristen Tarrin. We'll do a little bit more detailed introduction, but Kristen, if you don't mind if I call you by your first name, Magistrate? All right.
Yes, of
Kristen?
course. Yes.
Kristen, thank you so much for being here today.
Thank you for having me.
Absolutely. Well, let me tell the world about you, because I think your background is really interesting and the things that you do in your spare time. I think we're going to want to dig into that a little bit as well. So Kristen has been practicing family law in Colorado since 2007. She has been a child and family investigator since 2019, and we'll ask you to explain to our audience a little bit more about what that is, and a child's legal representative and a guardian ad litem. Those are different roles, and we'll probably get a little bit of definition on those as well, since 2022. Kristen has been a part-time magistrate since 2023 in different counties in western Colorado, and her entire docket consists of domestic relations cases. Kristen is an international referee for powerlifting, and I want to know more about that for sure. And when Kristen is not working with kids or powerlifting, she enjoys spending time with her dog, Brad the Pit. Love the name. Love the name. So, Kristen, thank you for spending some time with us this afternoon.
Thank you. I'm looking forward to it.
So, question, just to start definitionally, what is a child and family investigator? What is a CFI report? What is a parental responsibilities evaluation? Those are unique to Colorado, maybe, but at least that's what they're called here in Colorado. I think other states have similar things, but can you tell our audience what that is and what you do?
Yes. So, a child and family investigator, I believe, is similar to what GALs do in other states in some instances. Essentially, a child and family investigator or a CFI can be an attorney, can also be a mental health professional, it can be a teacher. There's really no licensure requirement. The only requirement to be a CFI is to take a 40-hour class in addition to 20 hours of domestic violence and child abuse training. So really 60 hours to get on the list. And then the process is it's a court-appointed neutral, so we don't work for parties. I may think we do, but we don't. CFI then will talk to each parent or psychological parent or grandparent or whomever is part of the process. We'll talk to collaterals, usually teachers, if they'll speak. Unfortunately, a lot of teachers will not talk to CFIs. They do not want to get involved. But if they do, they are a great resource of information.
I bet.
We will talk to therapists, counselors, friends, neighbors, things like that. And then we'll talk to the kids. Now, this past weekend, I had 6 home visits. All 3 families, so it wasn't 6 different families. But I did speak to all
Oh my
these kids.
gosh.
Yeah, and all these kids were fantastic. All of them were great. But one home, the kids were teenagers, so we had real substantive conversations because they're mature enough to be able to do that. One was a 1-year-old and a 3-year-old, so there was no conversations there. It was me just watching them with their parents. And then one was a 6-year-old. It was sort of in between. I asked her some questions. I'm not so sure how mature she was to answer them, but you can still even get an idea of how the kids are doing, even if they're not mature enough to make an informed decision, which is one of the elements of the law in Colorado anyway, is the court has to consider the children's wishes if they're mature enough to give a reasonably thought out opinion. So that's part of what the CFI does.
So can I ask you a question back to the training element of this? Because we have some similar, roles that describe, like the GAL role in this trainings as well. But in terms of child development and your observations of kids who are 6 or who are 2 or who are 14, like what does the training consist of that you're receiving?
Not a lot. Which I'll circle back to that, but that brings me to what a parental responsibilities evaluator. Those are done by mental health professionals, and they do testing, and they're the ones that I think really get more in depth on the mental health issues and developmental issues. CFIs really are not meant to dig that deeply, although I think more attorneys expect us to, but that's really not the role. The role is to really be information gatherers, provide that to the court in a succinct 15 to 20 page report, maybe more depending, and then give recommendations. I don't know that my recommendations are that critical. I will say, as the magistrate, when I read reports, I look at the recommendations, but if I don't go by, I don't always implement them as a rule. When I'm looking at a CFI report, the thing that I am most interested in is what the kids say, especially if they're old enough. And then, of course, what neutral collaterals will say. So to go back to your question, Heidi, we don't have a whole lot of training there. And I do think it's important that we do. Now, we have to do 15 hours every 5 years of ongoing domestic violence training, but it doesn't specifically say child development. There is some I've done hundreds of hours of domestic violence and child abuse training. And so there is some child development in there, but there's no specific requirement for that type of training.
So, just theoretically, somebody who has no background other than an interest in sort of family law or this sphere could take those courses and be, as you said, gathering facts, information, observing, almost like a reporter, and coming back and saying, this is what I observed, and hoping that that's a neutral observation.
That is true. However, CFI still have to apply. So I don't know the percentage of people who apply who actually get to take the class. There may that might be an interesting question to ask the SEA on that, but I do believe you have to have references. They do ask some of those
Right.
questions.
I think that's right. I taught in that, in the CFI, 40-hour basic training, as well as in the 20-hour trainings for domestic violence. Um, and I don't know the answer to that question. How many people apply that are told no, thank you?
Might be interesting to find that out. I don't know either.
Yeah.
And the training is only every 2 years, so it's not like I guess anybody could theoretically do it, but it is mostly attorneys and mental health professionals who do it.
Yeah. I mean, it sounds like it's sort of self-selecting, but it's a lot to do if you're not interested in being helpful in doing that. But I just wondered if
Absolutely.
a
It
layperson who who had strong opinions about the process perhaps could become involved in something like that.
Yeah, I've seen some paralegals who do it, and they do actually a great job. And I've seen some there's a preschool teacher who does most of the PRE or CFI work down in Southwest Colorado. The preschool teacher, of course, would have the child development. The paralegal maybe not as much, but yeah, you don't see many people, mortgage brokers coming to ask to be CFIs.
Right.
Yeah,
Right.
I would. Yeah, exactly.
So part of it is, following up with Heidi's question, it's reporting on this is what the kids told me. This is, kind of what I observed. This is what I heard from the neutral collaterals. But you also make recommendations on the parenting time schedule and what the parenting
Yes.
time schedule should look like. Do you, as a CFI, I know you talked about it from the magistrate's perspective, but as a CFI, do you have a sense of how often courts are straight up adopting what the Child and Family Investigator is recommending?
Yes and no. I try to go back and look at mine to see what the courts do. I will say my goal as a CFI is to have the parties settle. And unfortunately, my goal is not met more often than not. But when the parties settle and they settle based on my recommendations with maybe some tweaks here and there, that's a win in my book. Um, so those are actually very rewarding, and I love to see that. When I do see, I think like Judge Michael Lord Blegan is she was a CFI, she was a magistrate. She has a mind of her own. She is not going to follow my recommendations in lockstep. She's going to do her own thinking about it, which is
Right.
good. Um, Whereas maybe somebody who's just appointed, who was a public defender, who doesn't have a whole lot of experience in DR work, which is domestic relations, might be a little bit more apt to take my recommendations. Where I wonder about sometimes, and I think I am either hired or not hired because I am a part-time magistrate. I wonder if people think, oh, well, the judge is just going to take her recommendations because she's a judicial officer. Um, so that's either why they will or won't hire me. And I know that there are some people who haven't hired me because I am a judicial officer, and that's fine. Um, I hope that that's not the case when it comes to the actual case. I hope that the judge does their thinking for themselves. But I would also hope that me being a magistrate does lend a little bit of credibility to what I'm doing.
Yeah, I'm sure it does. Absolutely. So you talked a little bit, Kristen, about the domestic violence training that you do first as part of the initial process of becoming a CFI, and then also the ongoing training that you have. If you could talk just a little bit more about that, and do you think, I guess it's sort of a two-part question, tell us about the training around domestic violence coercive control, and do you think that CFIs get enough training around those issues?
Uh, yes and no. So, first of all, when the first iteration of we don't call it Cadence Law, but it's basically that's kind of where it all started.
Right, right.
The first iteration of that was in 2020, and necessity is the mother of invention. The Colorado legislature passed this law, take this class, and everybody, or take these hours of training, and everybody said, "Okay, great. Where's the class?" The legislature and the SCA, I was like, "We don't know. You figure it out." So, to many people's credit, three or four different groups did courses, and Julie, I think you did one as well. I
Correct.
took all of them because even though we were only required to take one, I still took all of them because I'm a little bit crazy, for one. I also feel like fundamentals, you can't get enough of them. And it was very interesting to me to also be able to compare what these three different courses had in common, um, and maybe where the differences of opinion were. But they were all very good. And I appreciated all of them. They're all online, so it was easy to do them. And I would say, again, as if we're just basic information gatherers, then they're perfectly adequate. Where we get into some concern or problems is, again, because the CFI has a cap of payment. Our payment cap is $3,250. Now, many CFIs will ask for additional fees if they feel they need it. I don't, for the most part, for many reasons, which I can go into later if you want to know. But so for 3250, you can only do so much. Whereas these PREs, the parental responsibilities evaluators, can run into the 20, 30, $40,000 range. It's
Or more. I've
very,
seen
yeah.
I've seen cases of half a million
So
on
right.
PREs.
Yeah, it's nuts. And so the CFIs then are sort of the people who can't afford.
Wait, I have a question.
Yeah.
Um, so the PRE, like, you said they're mental health people who are trained, but that's also a broad range. Like, what does that mean? And what is that? How qualified are the people and what's the training there?
That's also kind of up for debate. I personally, if I'm going to get a PRE for my personal whatever, I'm getting a PhD because if they're going to charge that much, I want someone with that. But it's not required. There really isn't any requirement. They can even farm out the mental health assessments. They do need to do a minimum of assessments like an MMPI or some of those testing, the mental health testing. But some of the PREs don't even do that themselves. So some of them are glorified CFIs. They do exactly the same thing, except can charge more. Now, they can also spend a little bit more time talking to collaterals. Like I know a PRE who's retired now. He would go to both homes and have dinner with them. He would make them make him dinner, which I don't know if he liked that or not, and he would spend time with the families. So yeah, the qualifications really, I mean, LS what license LCSWs can do it. Just regular psychologists can do it. Anybody with a mental health background, MFTs. So yeah, so that's where you really want to be if you're a practitioner wanting to spend that kind of money. I'm spending it on a
So
a psychologist, a PhD.
are there some, PhDs you've worked with who like that's their full-time gig, that this is their job, that's what they do, or there people who specialize and do this infrequently, or what's your experience?
The one who I loved, who's now retired, was Dr. McNamara.
Mhm.
But she still did private practice. I think a lot of them, because the work is hard and it's very labor intensive. So I can't, I don't know if I'm sure there are probably some that's all they do, but I think most of them also maintain a private practice.
Mhm. Yeah, do you think that people get enough training as child and family investigators, and the parental responsibilities evaluators are also supposed to do the same training, the 20 hours plus the maintain the 5 hours a year?
Yes and no. I think a lot of this, especially with coercive control where there isn't a bruise or a scratch or a mark or whatever, it takes being in it and seeing it a lot and not necessarily experiencing it yourself, but seeing what that looks like. So the experience, the training comes with the experience of seeing it, um, which uh, I guess could be a double-edged sword, sort of, because if you don't have the training, you might not see it nor notice it. Or what I don't want to be is a hammer looking for a nail.
Yeah.
And I
Mhm.
think sometimes with the little amount of training we have, that can end up happening because it's look for these high level things like does she is the wife on an allowance? Oh, well, he only gives her $50 a month, so there must be coercive control. And they don't look into well, he only gives her $50 a month because she asked for that, or because that was their family plan, or because she's filed
Mhm.
bankruptcy 4 times and he's trying to protect the money, the family. I don't know. I mean, there could be many reasons. So that's my other concern, not necessarily about do they have enough training to recognize it, but do they not have enough training to recognize when it doesn't exist or when there's some nuances there that could maybe be tweaked a
Mhm.
little bit?
Mhm. What do you think, parenting can look like, after, divorce or separation when there is domestic violence involved?
I think that really is specific to the families. I think just because there was domestic violence in the relationship doesn't necessarily mean there will be child abuse to follow, which I think a lot of people make that assumption, which they're not always wrong. But I think we need to be careful there. And while domestic violence is domestic violence, whether it happened 1 time or 20 times, I do think we also need to look at the context of it and that, okay, so both of these parties are really stressed out. One of them's calling the F and B word every 3 minutes. The other one's looking at their phone, calling them 1,000 times. Things that are not healthy behaviors, but that are really compartmentalized into their situation at the time. Whereas once they're separated and kind of out of this high stress, probably won't happen. So we have to look at that as well. Now, physical violence, I'm a little bit more careful to say that. I'd really want to know why that happened and when. And it doesn't necessarily mean the aggressor can't have parenting time. There's plenty of programs and places that treat anger management, domestic violence. Safe and Together is a program that really does holistic training and it keeps the whole family involved, not just the victim, but also tries to work with the
Mhm.
perpetrator. And so programs like that, I think, can allow for parenting time because, for instance, one of the families I visited this weekend, two teenage girls where their dad definitely has committed some domestic violence against their mom. They have their own phones, they can self-protect. They want to spend time with their dad. They're not scared of their dad. They like their dad. So in that case, I'm going to recommend they be able to dad have parenting time because of those reasons. Now, if they were 2 and 4, maybe not. Maybe it would be more of a
Mhm.
supervised thing until he took some anger management courses or something like that.
So it sounds like what you're saying is it depends on the situation. It depends, and obviously, right? But it also uh, speaks to the recommendations that you can make as a CFI or presumably a PRE can also make to put protective pieces in place and to recognize what needs to happen, whether that is domestic violence treatment of the perpetrator or safe supervised parenting time, all of these different things. So it's not like a automatic checkbox one and done, right? That everybody gets the same cookie cutter.
Right, that's correct.
Okay.
But the statute is pretty clear, though, that if there's domestic violence, the court, well, for decision making, which is different, but the court can put in protective measures to make sure that everybody's safe.
So
Mhm.
if I'm not mistaken, earlier in the conversation, you said one of your goals when you do these reports is that people would settle, that it wouldn't
Hmm.
be involved. Yet we're talking about it almost like it's a foregone conclusion that there will be court involvement. So I guess my question is there ever consideration given to not just the report for the court, but the modeling and a template for the parents to effectively implement some of these things and be self
Yeah.
governing after the divorce?
Yes, definitely. And I do try to put in admonishments, for lack of a better word. Sometimes they work, sometimes they don't. For example, just as this isn't a domestic violence one, but the parents that called this little girl two totally separate nicknames. And she's like 2 years old, and I don't know enough to know if that's good or bad or if she's gonna be, civil or what, but, what I put in the report was, "Hey, you guys might wanna talk to a mental health professional and figure out the nickname you both wanna use because, it's little things like that." Or, the fact that you feed her Cheetos at 8 and mom says no sugar why don't you guys, like, talk about these things? So I do try to give some guidance there. Now, again, whether they listen or not, I don't
Yeah.
know.
Yeah. No, I mean, I think, all these things take practice as well as punishment or advice or whatever you want to call it. But I think, how you model and create a mechanism for people to practice when their intention is not to stay together. So it's like, you have these competing, um, I guess, goals in a sense. One is to separate and the other is to co-parent. And, you know, trying to get that rhythm right and a system that works is of course really challenging.
It is very challenging, especially when you have one or both parties that just really can't see the benefit of the other parent in the kids' lives.
Mhm.
And, you know, there's not there are some bad parents, absolutely, but as a rule, kids love and want both of their parents. So the other parent needs to figure out how they can respect the other parent as a
Mhm.
parent, and they don't have to love them anymore or whatever, but yeah, that's always difficult.
As a child and family investigator, you spend a lot of time talking with kids. If a child and family investigator is not involved or PRE is not involved, how does the court get that voice of the child? And what and you've seen it from both sides, right? As a
Mhm.
magistrate and as someone who's making recommendations after talking to kids. How can the court get that voice of the child in a way that is helpful?
It's tough. There is an option of a child legal representative, a CLR, where the CLR then advocates for the best interest of the child. So the child is not the client, the best interest of the child is the client, which makes things murky at best. But then you also, when you have attorneys who don't like the CLR's position, they're going to make hearsay objections when you try to tell the court what the kids want.
There also the possibility of an attorney for the child, or is it always the best interest?
It's always best interest. Um, I guess you could potentially have a GAL if the child is disabled, but I've never seen it. So it's always a CLR. Uh, w- what I would like to see happen, and I'm starting to do this more, and I'm starting to. This may actually. I'm not sure if this is in the legislature now. I've been using, and forgive me if I can't. I think it's 807. Is that the catch-all where you can do
Mhm.
hearsay? So yeah. So
Yep.
I've told the attorneys, hey, I'm gonna ask the judge for hearsay under 807. Here's what the kids are gonna say. Here's what I'm gonna ask for.
Hmm.
It's Colorado
You
Rule of Evidence
Yeah.
807.
Figured. Yeah.
Yes, thank you. So that's one way, but there's also judges that will require the CLR at the beginning of a hearing or something, say, I want to know what the kids want. And if the attorneys object to hearsay or whatever, I really hope they do. And I really hope they appeal because we need some clarity on this.
Mhm.
Or we need the legislature to pass a law that says child hearsay is acceptable when it's given by a neutral,
Well, does
something
this
like
come
that.
in at this is a little bit for the audience, maybe a little bit more of a technical question, but are these reports coming in at a time of temporary orders, or are these only coming in at a trial? Because that's an
You
issue.
mean the CFI
That
report?
report- Yeah,
And usually they're going to be towards the end of the case because they take 90 to 120 days. I've had some judges ask me to opine at temporary orders, and I don't like that because I haven't done a full investigation. But typically, well, what the law is that if there's no due date, it has to be completed 35 days prior to the permanent orders hearing.
I see.
So, and there are some where they're like, I have to do a hearing in July. Can you do a report? I'm like, well, it's not going to be 35 days, but yeah. So as long as the parties agree to have it in a shorter period of time, that's okay. But to answer your question, typically these are going to be later in the process.
Okay, that's helpful. Thank you.
What about judges interviewing kids?
Um, okay, so I love it. I will interview kids all day long. But I have the training though.
Right.
And I will say that I was at a conference last year, which was judges, CFIs, attorneys. It was the conglomeration of a bunch of us. And a judge said, I don't want to talk to kids. I mean, I have my own kids. I know how to talk to my kids. I don't want to mess them up. I don't want to, do something to. And I piped in. I'm like, you're not going to hurt these kids by a 30-minute conversation. I mean, unless there's sex abuse or there's some real serious allegations of abuse,
Mhm.
at which time you say we're done. Even as a CFI, like I am not trained to handle that. I call CPS as a mandated reporter. We're done. As a rule, the judge is not going to hear that kind of stuff. I don't think they're going to hear. Yeah, they're going to hear. No, my mom's great. Even my dad says she's a jerk or whatever. And in a 30-minute conversation, they're probably not going to get a whole lot of information, but they are going to be able to at least kind of get to know the kid a little bit, but more importantly, that child is gonna feel like they've had a say in the process,
Right.
and I think that's really important. So But then we get down to dockets. My docket is good enough that I can do it. Dockets in Adams County, Arapahoe County, the metro dockets, they don't have time. And I wish they did, because it actually is
Mhm.
really fun to talk to them. And you get to know the whole family holistically, not just what they're
Yeah.
wanting you to hear.
And do you have an age when you think it's appropriate? Or are you talking about you talk to a 3-year-old, you talk to a 13-year-old?
As a judge or magistrate, I've only interviewed probably maybe 12 and older. And that's not because I have a rule, that's just the kids that have come in and have talked to me.
Mhm.
I would probably talk to any age, but not really. If you really want to get some substantive information, 10, 11-ish. I have some 10-year-olds that are super articulate and some 10-year-olds that are not. So same with maybe 13-year-olds. It really depends. Um,
Yeah.
but teenagers for sure. I have no
Mhm.
problem with teenagers.
Yeah.
Well, it's interesting in Colorado and sort of the bifurcation that we have with dependency and neglect cases, the child abuse cases where the state is involved versus domestic relations cases. In our child abuse and neglect cases, the children are presumed to be able to be at court hearings and to talk to the judge, and the judge is required to talk to those kids, really, no matter how young they are. But and the kids have more of a say over a lot of things as they get older in both realms, in terms of, like, they can choose a mental health provider. They can, keep that information confidential when they're in their mid to late teens, even from their parents, right? So that piece is common, but then in the family law realm, judges are like, "No, I don't wanna talk to kids, that's too scary."
Yeah.
But but one of the things that I did when I was on the bench was I had both those dockets, and so I got very comfortable talking with kids and talked with lots of kids of all different ages from 2 years old on up, and got great information. But again, that I think goes to I was trained, I came with a domestic relations and child abuse, and neglect background. So, how can we encourage voices of children? This goes back to my question from before. How can we encourage the voices of the children to be heard in ways that courts can hear them?
Well, I mean, I certainly, as a personal mantra, I guess, any judge who asks me, I will tell them to do it. Don't be scared of it. CLRs, like I said, I think if we could get, because the child legal representative doesn't write a report. The child legal representative is just the lawyer in court. So if I had my way, every single case would have a CFI and a CLR because the CFI can have the hearsay. Um, but most people don't have the money or the resources, and so that's a lot of people involved. But
Mhm.
the CLR is involved through the whole trial or the hearing and can ask questions, can cross-examine, can give evidence, can do all of that. So there's some ways the CLR can get in information from the children. The judge, of course, can talk to the kids if somebody asks and the judge says okay. Neutrals, if they're willing to testify. I personally don't like children's counselors testifying
Right.
because then that violates their safe space.
Correct.
Teachers can give some good information as well, but even then, you've got the hearsay problem.
Mhm.
So I really think the best way to get the kid's voice heard is through a custody evaluation, either through CFI or PRE or the judge.
So, Kristen, you are a Tapestry member. You have
Mhm.
had the Concilium mastery course and the training, and you did that, I think, shortly after I know shortly after I first met you in the CFI training. How do you think your Concilium training has impacted your work as a CFI, as a CLR, as every other acronym, including magistrate?
Well, from a networking standpoint, if people ask if I can't take a case, I send it to Tommy or Amanda, depending on what it is. So there's definitely some of that networking there because I know they've had the same basic training and I trust their instincts, if you will. And so I feel confident recommending other tapestry members. So that's a good bonus. Because I don't represent adults anymore, I don't have an opportunity to use it in my day-to-day practice much.
Mhm.
Um, but I will say, even as a child legal representative, and I see these attorneys who just can't see the forest through the trees, I will try to at least say, hey, let's have a conversation here. Let's all chat. Let's see if we can't come to some resolution. Sometimes it works, sometimes it doesn't. Um, and even sometimes as a CFI, I haven't actually had I don't interview the parents together. I threatened to sometimes. Um, but there I have had conversations with them of like, why am I here? You guys are so close on everything except this one issue. Like we're making this harder than it needs to be. Um, or just recently a case the one parent was very contrite. He had an affair. He was very contrite and he was like, I messed up my marriage. I want her back. I really want to reconcile. So I when I talked to the wife, I was like, "So, is there any chance you guys can reconcile?" She's like, "Nope, I'm done." I'm like, "All right, I'm not going to push it because I'm not your lawyer, or whatever." But I'm not going to just say, "Okay, I'm a CFI and I have to do my investigation. I have to write my report." If these parties decide in the middle, like, you know what, we don't need you anymore. I'm like, I'm fine with that. I will go play golf or go powerlift or do something. Because in my mind, you are so much better off coming to agreements on your own than having me or the judge or somebody tell you what to do. So I think Concilium has helped with that to really try to be more because just because someone's getting divorced or going through a breakup doesn't mean they have to hate each other. They can, you know, even if there was an affair, even if there was bad things, let's try to put the kids' needs first.
I think obviously it's really hard when someone's, feeling really salty, betrayed, angry, all those things. It's hard to sort of make that psychological shift. But I think one of the things I hope people get from the Concilium sort of practice and training is this idea of restructuring a family as opposed to divorcing and really saying, if we're in this for 5, 7, 12 years together for our children, not for each other, but for our children, how do we create platforms, templates, systems so that we can effectively work together in this new construct? And that's, I hope can inform this process a bit.
Yeah, I totally agree. And it's funny because I hate the word co-parent because it is never used in a positive way. It is always used in a negative way. Like, why can't you co-parent? You're not being a co-parent. And so I wish that language would get reframed as well because I said they're both parents. The co is fine. It's true, but it's used as a sword, not
Well,
a
it's funny that you say that
shield.
because I had a client many years ago who was objecting to the word co-parent in the agreement. And to me, at that point, I just thought, they're co-parenting. Like, why is he so upset about this? And I said, would you have a better word? And he said cooperative parenting, which I thought was sort of funny because it was like that what the co's for. But it was the fuller explanation. It's like, can we say what we're doing? And it's in his mind at least, co sounded 50-50, and his position or feeling was that he was doing more, he was responsible for more of the children's residential time at that point. And he was fine
Mhm.
with their mother, but didn't feel like it was like that it was equal. And so it was like, yeah, sure, I'll cooperate, but we're not co-captains,
Okay,
co-executors, parents. It
Right.
was interesting how
that makes sense.
words matter, and I think that
Yeah.
give definitions to you, you're wise to listen, as attorneys and as people who are helping families restructure. These labels really give they're much more than words alone. They create sentiment. And
And I will tell you in my reports too, I try to never use the word off. Like, you'll hear it, we're a week on, week off. I say, and I know it's more words, but I don't care. I say you are a weekly rotating schedule
That's
because you're
great.
never off as a parent.
great. I love that. Yeah,
Yeah, that's
that's
really good.
so true.
So I do that. And I know you both know because I said this on our first days. I try also to never use opposing party or opposing counsel.
Yeah.
Mhm,
Just because the words do matter, and the less acrimony we can, or the more acrimony we can pull out and leave aside, the better.
Yeah.
mhm.
It often doesn't take so much more thinking. But like when you hear a word that you find offensive, assume other people will and think, what other word would work
Right.
here better.
Right. And really sort of shifting that perspective, right? One of the things I've started doing when people are talking about co-parenting is to say, well, at minimum, you're coordinating your parenting. So that's a different way of thinking about co-parenting. You're coordinating your parenting. You've got to know what the kid's schedule is. You've got to know what the calendar looks like. So that's sort of the baseline of co-parenting, right?
Yep.
Yeah. Yeah, 100%. So I have a question for you, a little bit off here, but you're an international powerlifting referee. So
Mhm.
Yes.
if that informs your magistrate practice or vice versa, if yeah,
It does in a way. It does. And I'll give you an example. This past week I was in New Orleans at the Collegiate Nationals. And it just so happened, I don't know why, I had 3 or 4 lifters from CU on my platform. So of course in my brain I'm thinking, "Go Buffs, get the lift," but the referee in me has to be like, nope, I don't care where you went to school, you are a lifter, I'm gonna just judge the lift as is," which I did. But what ended up being really funny was one girl made an unofficial world record because you can't do world records there, but she made an unofficial world record from Colorado, coaches from Colorado, plus there was another Colorado referee on the platform. And I thought, this is not looking good, guys. But so it does. It actually does. And also, and both of these play off of each other. When you're refereeing in a big national or an international competition, it's 3 or 4 days of nonstop yelling, cheering, yahooing, the athletes in their schools, and as the ref, you kind of have to yell your command, so you're losing your voice. And by day 4 in your 7th session, you're tired, and it is so easy to just kind of half-ass it. Sorry for the language. And I always remind myself this may be my 7th session, but it's their first. And that's what I always have to remind myself as a CFI. Like, okay, you can't half-ass this. This may be like an easy one, but it's still their lives. And they deserve the same amount of effort as you're going to put into the one that's got the sex abuse and the nasty stuff, whatever. Um, and the same with being on the bench. So it's 4 o'clock and you have another protection order that's like, oh, they said boo to me and I'm scared. So you still got to listen to them. You still have to take their concerns as valid and as if I would in the morning when I'm super bright. And, and
Mhm.
I know they've had the studies about the harsher sentences with judges, I think come after lunch or before lunch or something like that. I don't
Right,
know.
right.
Like, well, I'm not going to be that judge. I am not.
But
So,
you have
but
to
so
fight
the
against it, right? You have to be
yeah,
conscious about it.
yes. But
Yeah.
that's how those two things really help me with with the other is knowing that it's not about me, it's about them.
yeah, that's great. That's great.
Very cool. Kristen, this has been a delight. Thank you so much for taking some time to talk with us today. If people want to find you, they can find you through your website, Tarrin Law, TARRIN law.com. And your experience, expertise, and passion for making sure that children's voices are heard, whether you're doing that from the perspective of an investigator, an evaluator, or from the bench, is really profound. So thank you for the service that you give to families in Colorado, and the information that you've shared with our listeners today.
Thank you. I appreciate it. And yep, I'm happy if anybody just wants an ear or even wants a CFI report read to see if they should do a work product review or something. I'm happy to do that, and I don't charge for that.
What is a work product review? Let's just take a
Yes.
minute and
Okay. I
fill
will.
that out.
I will. Yes. So work product reviews are, if somebody doesn't like the CFI report, they can hire an independent CFI to review just the file. They don't talk to the parents. They don't talk to the kids. They don't talk to anybody. They just review the file. And then they will write a report. There's no limit on costs. These things could cost more than the report itself. I have been reviewed 4 or 5 times. One time, the review was legit, like had some legitimate stuff to say about me. So I actually called the CFI and thanked him, and we had a great conversation. Most of the time, they are not. And I have been asked several times to do work product reviews. I have done one. And I will do them if I really feel like the CFI not just got it wrong, but really didn't look at things they had to look at. For example, the one I did, which Julie knows the case,
Mhm.
she didn't look at any, like this one was a case where there was blatant coercive control in my mind, like blatant, didn't even address it. So that was one where I felt, no, this deserves a work product review. Most of them don't. Most of them are, I just don't like your recommendations, or you didn't talk to the kids' school, so you suck. I'm going to, whatever. So I'm happy to read through reports and say, this is not worth a work product review. Or, hey, their criticism here is the alcohol use. Why don't you just go start doing some testing or do something that shows you're not drinking or whatever, to give some ideas so they don't have to spend another $3,000-$4,000 on a work product review that's probably going to go nowhere.
Yeah, that's super helpful. Is that something that someone has to ask the court permission for? Are the reports otherwise under sort of lock and key in the court, or what happens once those CRI reports are filed with the court?
So the CLRs don't do reports, CFIs do. That's, yeah. So the CFI reports are controlled by the court. They're not confidential necessarily. I use the word controlled by the court. Again, language matters. They are not to be disseminated to people outside of the case. Happens all the time, especially if they're remarried, they let their spouse read it. Technically, they're not supposed to do that.
Mhm.
Um, but but the court does have control. Now, I put in my reports, if there are mental health professionals, please share the report. Please share the report with them if they want it, because technically they're not supposed to do that either. So, so they're confidential to the parties. No one else is supposed to see them. They are under seal, so not like if I'm just a schmo attorney and go look into a case, I can't pull that up. It won't come up for me. Um, so they're somewhat private. Does that answer your question?
Yeah, but if somebody wants to have the work product review, they've read it, they've shared it with their spouse, like whatever. Like, how do they go
Right.
about doing that?
So yeah, so the work product review then, that's a really good question, Heidi. That technically might actually be a violation because the court doesn't have to give permission for that. But the party will give the CFI report and the case file to the work product reviewer, and they have it.
Mhm.
And the court does not have to give permission to do that. Well, maybe they do now. I'm going to rethink that. But they don't typically
Right,
give
right,
permission to do that.
right. So you're coming in as an expert for witness for the party that's asking
You
for the
haven't been
work
qualified by
product
the
review. Right.
right,
But
but you
then
haven't
do you
been
testify,
qualified.
right? If you right.
Yeah. Yeah. I mean, I have never seen a judge have a problem with them coming, testifying to coming in there. I don't know how much they use their reports as good evidence, but yeah.
Mhm.
but they can come in as evidence. Yeah, that's interesting.
Yeah,
Thank you so
cool.
much for
Sure.
this conversation. I've so enjoyed it. This is great.
Well, good. Well, and yeah, I'm happy to, if anybody has any questions or thoughts, please reach out.
So Kristen Tarrin at tarrinlaw.com. Kristen can also be found on the Consilium Institute website as a Tapestry member, as a Consilium practitioner. So consiliuminstitute.com. So thank you so much, Kristen. And go lift or whatever it is you do. I don't understand. But
Go
go
lift
for it.
heavy
Today,
things. Go
t-
lift heavy
today
things
is
and stay
deadlift day.
neutral.
So, yes, I will. Thank you so much.
All right. Thanks.